Your Honor, Joe Barton, appearing on behalf of the plaintiff, Your Honor.
Oh, no, the two of you. No, I meant that was actually a sign of joy. No, go ahead. All right. Where are we on this case?
Your Honor, this is a termination of tenancy case. There's a proper 30-day notice given. The lease expired April 30th, 2023, and we're asking for a possession judgment. And in Section 8 was also given the 30-day notice. We're asking that we give a judgment immediately for the 10-day to move out. She's had 30-day notice plus 10.
Response.
Your Honor, I entered this case yesterday. On Tuesday, I emailed and asked for the letter of release and the pleadings and did not receive them. I do need time to review them for possible defenses. By way of background, I think the background is relevant in this case. Ms. Green, I defended Ms. Green on a MSHA voucher termination, and we received a favorable ruling, but her MSHA filed exceptions and was waiting for a decision from MSHA. In the meantime, Ms. Green received notice that she needed to leave this property. I reached out to CMA immediately and asked for them to move her. And they have been basically avoiding doing that since, I want to say, maybe 8 weeks. And finally, yesterday, they stated that they had never received notice. Like, I have been asserting that Ms. Green could be moved if the termination of tenancy was involuntary while we were waiting for the MSHA decision. And they have been accepting that. And finally, yesterday,
Who had not been accepting
that? CMA. And finally, yesterday, they asserted that they had no evidence that it was an involuntary move because they had no evidence that the landlord was opting out of a HAP contract. So there's an issue there that I need to investigate.
Well, but that issue solved by their notification to Section 8 that they're terminating.
But Section 8 is not verifying that that has happened.
We have a letter, Your Honor, stating that they received it. I don't have that with me, my client, but I do have it. They did receive notice.
Right. I guess my point is that issue is something that's simply resolved. Either the landlord did it or they didn't do it, but if they have proof that they did it, then that now rests with CMA.
Well, Your Honor, by further way of background, Ms. Green is disabled. She's been in the hospital this week. Her newborn premature grandchild came home this week and now has RSV. Also, Ms. Green has related to me that she's had discussion with the landlord that the landlord would work with her to give her time to move. And then I got a different story from opposing counsel today. So I just need time to investigate the facts and see if Ms. Green has any defenses, Your Honor. And so I'm asking for an adjournment just to give me more time to find out what's going on in this case, because I asked for pleadings and things that I needed. I felt to investigate it, and I haven't received them.
But I guess my point in this would be what you said to me really don't have anything to do with the landlord.
I think there's possibly a retaliation defense, Your Honor. I need time to investigate it.
Retaliation of what?
Well, my understanding is that Ms. Green, the lease ended in April, and she's been a month-to-month tenant since then.
Right.
And my understanding is that there was an investigation. I'm sorry, not an investigation. That the premises were inspected, and the landlord was told that things needed to be, certain repairs needed to be done in order for the contract to continue. And because of that, there was a decision to terminate the tenancy, and there may be some element of retaliation in that, and I need time to investigate it. She's also disabled.
Whoa, hold on. That process would take place in a very different way, wouldn't it? I mean, if they inspect and CMA says this doesn't pass inspection, the landlord doesn't want to do it, it doesn't do it, then what would actually end up happening is they wouldn't pay. But that's not what that's not what I understand didn't happen here.
That's correct, Your Honor. My client has made repairs but the property, it's a month-to-month tenancy and a proper notice of termination. And he has the right to possession, and I'm asking for possession judgment, Your Honor.
And I'm asking for time to investigate and see if Ms. Green has any defenses to termination tendency.
They asked for a jury
But
trial,
what-
Your Honor. I'd ask that be denied, but there are no tribal issues of fact.
I don't know what I'd be trying. I mean, and I don't mind giving you some leeway to try to look at it. I don't typically have a problem, but when you articulate it to me, I don't see anything that the landlord, I mean, there might be some issues you may have with CMA, but I don't see where the landlord has done anything.
Well, Your Honor, if I had received the discovery that I asked for, I entered an appearance yesterday because I had not received any documentation that I could look at and see if there are any tribal issues.
But what documents were you looking for? Just what's in the court file?
The pleadings, the ledger, lease.
But there isn't a lease.
There isn't a lease.
But I didn't know that until 10 minutes ago when I was shown the lease.
Your Honor, I received her email after 5 o'clock yesterday, all right, in regards to her appearance. Prior to that, I had no idea that she was appearing.
Your Honor, I emailed and said that I was trying to assist Ms. Green on Tuesday in the morning.
That's not,
Received no response.
that's not an appearance. And I asked my client and I received a copy of the lease, which I have, but it's not relevant, and a copy of the ledger, which also isn't relevant. We're asking for a possession judgment. Proper 30-day notice was given and Section 8 was notified, and we're asking for possession judgment. And this is our second appearance. Judge Barr advised Ms. Green appeared last week and had the advice of rights.
Bauer, isn't the real issue here trying to get Miss Green moved? And when we cut through all of the stuff, the judgment really isn't necessarily the issue. All of that's really not an issue. It's trying to find a place for Miss Green to land safely. I mean, isn't that really what we're looking at? I mean, I'm just a plain talking guy. So I'm just saying, isn't that really what this is? Because the thing you led with is that CMA said that they didn't get something so that she couldn't move. Because we would, if they said, yeah, we got it, and she could move, we wouldn't be here today, right?
Yes, but I also think it's relevant that she's had conversations with the landlord that she's relied on, that she would be given time to move. 10 days is not enough time to move.
She had a 30-day notice.
So how much time would you suggest she be given to move? If now CMA says, yes, we have the documents we need and she can move, and how much time?
I would have to verify, but my understanding is that's at least a 30-day process. And I would need documentation to show CMA that the landlord did properly notify Mishra that he was opting out of the HAP contract in order to jumpstart that process, because they're still denying that piece, and that's what's holding everything up. But she's disabled and there's a newborn, premature newborn in household. And if we say that she has to be out in 10 days, then they're going to be homeless.
And I understand that.
And there may be a defense if I have a chance to look into it. I'm asking for time to investigate defenses and possibly file an answer.
I'm asking for a possession judgment.
I Miss
But
Barton.
you understand that.
Miss Barton, I know you led with that. I actually, while I look crazy, I'm not. And I actually do hear, even though it looks like I'm not paying attention.
It's nice to see you in person again.
Yes, good seeing you, Miss Barton. Um, I'm gonna give you 1 week. But I'm just telling you, Miss Bauer, don't come in here with a lot of junk. I mean, because this is a termination. They've terminated, they've opted out of the HAP contract, and your issue really is with CMH. Don't be blaming the landlord for that. And I'm gonna be, today, I'm in a position where I would cajole as best I could, Miss Barton, her client, to give your client time. But I'm giving you this week to look at it. Don't be asking me for any additional time if there's nothing there.
I understand. I just want a chance to see if there's something there, so I appreciate that.
January 26, 2024,
11 a.m.
11 a.m.
You're right. If I can just.
All right, what are we doing on this?
Your Honor, we had a second hearing 2 weeks ago, and Ryan, Mr. Halicki, filed an answer approximately last Friday on the 9th. And we are here for hearing, trial, what pleases the court.
All right, have the parties talked?
There have been some communications. Mr. Halicki provided me with the answer and counterclaim, as well as photographs and various documents. We made a proposal to essentially have Mr. Halicki walk away from the property in 10 days or some amount of time without penalty, and he declined that offer.
What do you want to do in this case?
I would like to pursue with my countersuit because still there's no C of O on the property. They don't have a license to own and or operate a mobile home park. So.
Okay, and so assume all of that to be correct, right? Just for the sake of argument. What would you see coming out of it differently than you being able to just walk away and be done? Because here's the thing, if you're right on your claim, and I'm not saying that you are, but if you're right on your claim, that means you cannot reside there. Pardon?
I don't know, Your Honor.
All right, let me ask it in just a plain way. What would you like to see happen in this case?
I would just like my counterclaim to be considered and see if we can make a result of that.
Your counterclaim will be considered. I mean, you filed it, okay? But in the end, what do you see coming out of this for you? What do you want for you out of this whole thing?
Oh, I mean, I already know I'm going to have to move. I'm just trying to preside my case and just see if we can come to an agreement or something of that sort. I'm fully aware I still have to move regardless. I mean,
Gotcha.
Okay.
So if I look at this, if you know you have to move, then is it an issue of time? Is it what?
It's kind of between time and the money situation. Unfortunately, I'm without a car and I'm self-employed, so I'm kind of very down right now. So,
Gotcha. And counsel, you were only talking 10 days.
That was the offer, but it was not.
Okay, so here's what I'm going to say. If you're right, they don't have a CO and can't operate it, you got to get out anyway, and I'd have to order it. Okay?
I understand.
From your side, if that's true, and again, I don't know if that's true or not, then it may be a circumstance where you might owe him money because you wouldn't be able to collect the rent.
Well, we disagree with his claims, Your Honor. In theory, in Mr. Halicki's world, that may be the case. In the real world, that is not the case. And Your Honor, one other note is his counterclaim is for $50,000, approximately, maybe $48,000 or $50,000. We should be entitled to possession and rent retained for the amount that's owed.
You're not going to do that to him, counsel. You know what he's trying to do. So you're not going to try to send him to circuit court. It's not going to happen.
Your Honor, if I could.
I will take jurisdiction over the case.
Thank
And if I have to get myself assigned to circuit court judge to hear it, I'll hear it. It's not going to happen that way. So don't play that game. Here's what you're going to do. You're going to go out and you're going to talk to this man. You understand the position that he's in. You understand the position that you may be in. You guys can work out a move out date. I'll pass it.
Thank you.